Good afternoon, everyone, and thanks for tuning in to today's IEEE USA Livestream webinar, Negotiating Your Professional Services Agreement, the Good, the Bad, and the Ugly. I'm your host, Jonathan Show. Today's webinar is done in partnership with the IEEE Member Discounts Program. To learn more about the program, you can go to the link provided in the stream and in the comment section. One moment, please, as I pull it up. Our presenter for today's webinar is Colleen Palmer of the Beasley Group. Colleen joined Beasley in December 2007 as an A&D risk manager and is based in the New York office. Before joining Beasley, Colleen was a practicing attorney in Boston, Massachusetts, where she focused on assisting architects and engineers. She specialized in providing risk management services to design professionals on a nationwide basis, including conducting risk management seminars and advising on contractual issues. Colleen earned the Bachelor of Science degree in biology from Cornell University and her Juris Doctor cum laude from the University of Miami School of Law. Without further ado, I'd like to pass it off to our presenter. Welcome, Colleen. We're very excited for what you have in store for our audience today.
Thank you, Jonathan, and thank you so much for inviting Beasley and having me back to give another webinar to your group. I'm excited to be here and particularly happy to talk about the topic today of negotiating your professional services agreement, because it is just so important, and I think that you can never stop learning and never stop improving when it comes to getting your contract appropriately drafted. So we're not going to talk today about every single provision that is in a contract. We would be here for weeks if we did that, but we are going to hit some of the provisions that really demand your attention as you're reviewing that contract with your client. We're going to kick off right off the bat with a quick polling question. And I'd like to know from the audience about how often you have a written executed contract prior to performing your services. So if people could click on the appropriate button. The question is, our firm has a written executed contract prior to performing services. And your options are on all projects, about 75% of the time, about 50%, about 25%, or almost never or never. So hopefully people will start putting those in. Oh, I see one person did. Good. So I'm seeing some people type in their responses, and I'm seeing 100% or almost 100%, which really is what we're aiming for here. We recommend that you have a signed written contract on all of your projects before you start providing services on that project. And it really is just so important. I think everyone at this point, this day and age, recognizes that an oral contract, these handshake deals, they really are inappropriate for you as professionals. It's not that you don't trust your client, but in the event that there is a problem or issues arise on the project that results in a claim, if it's just a handshake deal, you have nothing that's reduced to writing to reflect what you truly agreed upon. So the contract is a great area to outline the expectations, manage the client's expectations. It will define your rights and obligations, your scope of services, and of course your fee. You definitely want to have your fee addressed in your contract. So you want to make sure not only is it in writing, but you actually get this contract signed by both parties. I can't tell you how often I get a phone call or an email from a professional and they say, Colleen, we're just about finished with this project, or we are finished with this project, and the client is behind in paying us, and they said that they'll pay us just as soon as we sign the contract. And lo and behold, you look at the contract and there are a lot of provisions in it that are one-sided in favor of the contract and could present problems in the event something did happen with the project. So essentially the professional's fees are being held hostage. So that's another reason we want to make sure that you get it negotiated and signed before you perform services. So next we're going to go right, oopsies. There we go. We're going to have one more polling question. That'll be it for this whole session. But I'd like to find out what people think is the most difficult provision to negotiate with your client. And here are our options: incorporation of documents by reference, standard of care, indemnity, use and ownership of your work product, of your documents, or limitation of liability in your favor. So please do vote in the comments section. I can see those when they come up. Three, okay, someone, yep, people are putting in indemnity, limitation liability, indemnity, yeah. So I'm not surprised that indemnity is coming up as the most difficult provision to have appropriately drafted in your contract. And the good thing about this presentation is we're going to talk about all of these provisions, and we will get started. Thank you, everybody, for voting on that polling question. But we're going to get started, and we're going to talk first off about incorporating documents by reference. And we have here, the word risky, and it can be risky because anytime your contract incorporates by reference any other document, and often it'll be a prime agreement. So let's say you're a consultant to an architect or another consultant, their agreement with their client will be incorporated by reference. And what that means is that document is effectively stapled to your agreement. So your contract may be 4 pages long, but there's a prime agreement or some other document that's incorporated by reference that's 50 pages long. Everything that's in there is now part of your contract. So at the bare minimum, you want to make sure that anything that's incorporated by reference, you get your hands on, you review it, and ensure that it's acceptable to you from a risk management and professional liability perspective, and of course, a business perspective. We also recommend that you add language stating that that document is only incorporated to the extent it's consistent with the generally accepted professional standard of care, and that in the event that there is a conflict between the document incorporated by reference and your agreement, that your agreement will govern. Very often, I don't even have whatever that document is that's incorporated by reference. So we might not even know, at least when I'm reviewing a contract, I don't know what's in that incorporated document. So you definitely want to make sure that your contract, which is the one that you have the power to negotiate with your client and make any necessary changes, that document governs. Often these prime agreements, they've already been executed sometimes years before you're retained to provide services on a project. So there's really nothing you can do about what's in that prime document. You can only focus on your contract. If your client refuses to provide these documents that are incorporated by reference, then that's a big red flag, and you need to have that discussion with the client and say, hey, I can't sign this contract without that document, without being able to review it, because it'd be as if I'm signing my own contract without even looking at it. So it really is important. Get your hands on it and make sure that it's acceptable. Next up is scope of services. And this is an area of the contract that I feel sometimes gets passed over a little bit and not as fully examined as it should be. It really should be a detailed and defined section of the contract that lays out what are going to be your basic services, what will be considered additional services, so you're going to get more money for those, and to the extent that you know at the time of contracting, excluded services. So there are some times when you will know from the outset, okay, we absolutely are not doing X, Y, and Z. So you want to call that out in your contract to make sure that it's in there. Sometimes people ask me, well, why don't we just have a scope that says we're going to provide all engineering services and any and all engineering services, and then list out things that you're not going to do. There are a couple problems with that. You want to avoid open-ended scope. So we've got here these little balloons here. Each and every, all, complete, all necessary. Those types of words arguably expand what your scope is, because all means all. All is all encompassing. So if there comes a time in the project where you say, oh, client, we never anticipated that we would provide that service on this project, the client can easily point back to your contract and say, yes, but right here, you agreed to provide all engineering services for the complete performance of this project. And that puts you in a very bad position to try to support an argument where you didn't intend to provide those services. As far as just having a scope of exclusion, meaning listing the things you're not going to do, that's also not the best way to approach scope of services, because when you think about it, it would be impossible for you to list every single thing you are not going to do on a project. So again, you could be in a situation where the client says, oh, well, we thought you were going to do this. And you say, well, we never anticipated doing that. And they look back at your scope of exclusion and says, well, it's not listed here that you're not doing it, so therefore you have to do it. So that's another area to be aware of when you are defining your scope. And obviously you need to make sure that you have the experience and the resources to provide the defined scope. You want to make sure that the people in your firm have the appropriate amount of experience to provide the services. And you also want to make sure that those people have the appropriate amount of time to dedicate to perform the services. You don't want your staff to be so thinly spread that there's an increased chance of having errors and omissions on the services. So you got to have the right people who have the right amount of time to provide the services appropriately. Okay. Oh, and one other thing I want to talk about here, the second bullet point, consistency between the agreement and your proposal. Sometimes your proposal will be incorporated by reference. Typically, if it is, it will only be for the scope, and the client will say any kind of terms and conditions, including limitations of liability, that's not included, but your scope is. So if there's a discrepancy between what your scope says and what the scope is defined in the contract, that can again lead to this tension of, well, are you supposed to do it as part of basic services, or are you not supposed to have to do it as part of basic services? So you want to make sure those align for sure. Okay. Next up is a very important standard of care. And I always include Black's Law Dictionary definition, just kind of as a reference point. The common law standard of care is such that you are required to perform the same level of care and skill as would ordinarily be exercised by your peers, performing the same services at the same time under the same circumstances. And the paragraph below is the standard of care language that we generally recommend. If a contract is silent on the standard of care, we do like to have it explicitly stated. Arguably, if a contract is completely silent on the standard of care, the common law standard of care should apply. But that's a little bit of a dangerous way to go about it, because a lot of times in your contract, there will be other areas, other provisions that hint at or are explicit elevated standard of care, a guarantee or a warranty, a certification. So you want to make sure that you are very explicit that this is your standard of care. You're going to perform in a manner consistent with, which sets this base, the bar of what the standard of care is, but limited to, which sets this floor ceiling concept. So you're not going to be required to perform anything beyond what is ordinarily exercised by similarly situated professionals. This is something that comes up over and over again in the contracts I review for Beasley's policyholders. It is one of the provisions that so often is problematic and onerously drafted that could inappropriately elevate the standard of care. And here are some ways that that standard of care can be inappropriately elevated. I kind of alluded to the fact of warranties, guarantees, and certifications. Those are inappropriate for you as a design professional. General contractor, trade contractor, yep, they can give those guarantees all day long because they're providing goods. You are not providing goods or widgets. You're providing professional services. Warranties and guarantees and certifications goes beyond what your professional liability insurance policy covers. And that's not just a Beasley thing, that's across the board. So you want to make sure that you don't have those in there. Superlatives. Anytime you see words such as highest standard of care, best services, first-class services, first-rate services, world-class services, you see that a lot on projects that are performed internationally. Any kind of superlative word like that inappropriately puts that standard of care up a peg beyond what is reasonable. Best and highest means arguably perfection. It means the best. It's not the level of consistent with and limited to what's ordinarily provided. Performing to the satisfaction of client or in accordance with client standards, these are tricky. They sneak in all the time. You may not know what the client standards are, but if they're adding that as a requirement for you with respect to your standard of care, you can be sure that it probably is something beyond the common law standard of care. Likewise, saying to the satisfaction of client, completely subjective. Your client could be happy with 99% of the services you provide, but if they're unhappy with one little thing, then by definition, it's not to the satisfaction of client. And that goes beyond the reasonable standard of care where you are not required to be perfect. There is an expectation that performing in accordance with the standard of care will have some errors and omissions. It does not necessarily mean that that rises to the level of a breach of the standard of care. Because again, as a professional, you are not required to be perfect. This is not a widget or a good. This is a service that requires professional opinion, professional experience, and isn't not required to be perfection. Lastly on this slide is fiduciary duty obligation. And a fiduciary duty does come into play sometimes in contracts. It often will not say professional agrees that they have a fiduciary duty to the client. The phrase that you should look out for is that professional, quote, accepts the relationship of trust and confidence. And that is essentially saying you have a fiduciary duty. Fiduciary duty, take a little step back, by definition is the highest duty that you can owe to another. So here we already know it's a superlative, so that's inappropriate for you as a professional. Fiduciary duty is something that makes sense in a trustee type of a relationship, but not in a client professional relationship. So anytime you see that, you want to delete it. And even I recommend putting in an express disclaimer of the fiduciary duty just to drive home that point that we're looking at the common law reasonable standard of care, not the highest standard of care. All right, the dreaded indemnity. I'm going to take a sip before we dive in. A lot of you indicated that this is the hardest provision for you to appropriately negotiate in your contract. And I would agree with you. It is a tough one. And I've found over the years that they're not getting better or more clear in the contract. A lot of times you'll see indemnity provisions that may go on for a couple of pages. And sometimes it's pretty obvious that someone has tried to cobble together and pulled from different things and they don't even really make sense. So it is an area that you want to spend an appropriate amount of time on to make sure it's right for you. When I look at an indemnity provision, I break it down into 3 prongs. And oops, it doesn't look like they came through on this, but that's okay. We'll talk through it. The first is, who are the indemnities? That would be out here in this pink circle. And what I mean by that is, who are the people, who are the entities that you're going to be required to indemnify? And it should be limited to your client and your client's officers, directors, and employees. The issue we have is that a lot of times the definition of indemnities will be this crazy laundry list of the client's consultants, their successors, their assigns, their attorneys, their lenders, their other corporations. So way beyond the client and the client's officers, directors, and employees. You do not have a contract with those third parties. And sometimes you don't even know who they are because they'll use terms like agents or representatives, which is completely undefined. So because you do not have a contract with those third parties, you should not take on a contractual indemnity obligation in their favor. So you really do want to limit it to your client. The next prong would be this kind of middle purple ring here, is whether there's a duty to defend. And we do recommend that you delete the duty to defend. It is broader than the duty to indemnify because it's triggered by allegations of your fault as opposed to adjudication or proof of your negligence. The duty to defend is typically not going to be covered by your professional liability insurance policy. Oh, there, look at that. It's magic. Not going to be covered by your professional insurance policy. And so if that duty is triggered, it would be an out-of-pocket cost for you. And ultimately, of course, it's a business decision. I've worked with firms who will weigh the factors on a project. So they'll say, okay, well, for this client, we've got a great long-standing relationship with them. For this project, for this scope, this jurisdiction, they go through their whole analysis and they say, okay, we're going to leave it in for this contract. But they do so knowing that if that obligation is triggered and the client says, hey, professional, we've got this claim, I'm tendering the defense over to you. I'm handing the responsibility of my defense over to you, meaning I'm going to start sending you my attorney's bills. They do that knowing that that's going to be something that they have to pay out of pocket. Their insurance policy will not respond to that. Other firms that I work with, and a lot of times it's smaller firms, they say, no way, we just cannot risk betting the firm on attorney's fees that could be hundreds of thousands of dollars on a claim, on a project for which maybe we got paid $2,000. So it is a business decision. We always do recommend that you take out the duty to defend. It's pretty clear usually in a contract. It'll say that professional agrees to defend. It may say the word protect. Protect is the same as defend in the dictionary, so take that out. Sometimes there'll be an implied duty to defend. Usually it's coupled with that express duty to defend, but if you see words saying that you agree to indemnify for claims, proceedings, allegations, demands, lawsuits, those words suggest this upfront duty because they're talking about before the claim has been resolved. Lastly is to ensure, this is a last but not least situation, that the obligation is appropriately negligence-based. And I always stress the word appropriately negligence-based because your provision that the client proposes may in fact include the word negligence or negligent somewhere in the mix. And you may be scanning through and you see that word, you say, oh, great, this is okay because I see the word negligent, so we're good. But you want to ensure that your obligation is narrowly defined so that your obligation is limited to the extent damages are caused by your negligent performance of services. So that's kind of the magic phrase that we're always striving to get, to the extent damages are caused by your negligence. If you see phrases like indemnify for damages arising out of or related to in any way whatsoever, that's broader than to the extent caused by your negligence. Likewise, if you see, and I do see this a lot, that you'll indemnify for all damages and liabilities, except if caused by the sole negligence of the client. Well, first and foremost, anytime you see the word sole in a contract, 9 times out of 10, it is not going to be favorable to you. But in this instance, if it says sole negligence, if the client is 99% negligent and you were, 99, if they were 99% negligent, well, that's not 100%. That's not the sole negligence. Therefore, you have that obligation. Another way this is put in, that you'll indemnify except to the extent caused by the negligence of the client. So they take out the word sole. But again, that's not the same thing as saying that you'll indemnify only to the extent caused by your negligence. So it is a lot of wordsmithing. It can get very convoluted, but I would encourage you to take the time to make the indemnity obligation as clear as possible, because you don't want, in the event of a claim, to have a court or a jury or an arbitrator tell you what you meant by your contract, by a poorly drafted contractual provision. So you are best served by making sure it's crystal clear what your obligation is and is not with respect to indemnity. Now, I don't want to get too much into specific state laws with indemnity, but I will point out for our listeners who practice in California, with respect to the duty to defend, it is not enough to just delete an express duty to defend. There's case law out there, and we won't get into all of the case law discussion, but in California, you do need to include an express disclaimer of the duty to defend, because the duty to defend is implied in California based on case law many years ago. So that's kind of the overview of indemnity. And Jonathan, I'm not seeing my little, oh, there we go. Okay, so we'll move on to the next. So with all that said, to avoid people head spinning, I wanted to give you an example of what an appropriate indemnity obligation is. In the event that your client says, hey, we want you to indemnify us, but we'll let you provide that provision. Number one, that's never going to happen. But if it did, here's an example, and you can see that it addresses the issues that we've been talking about, in that there is no duty to defend, either express or implied, and it's got our magic phrase that you're indemnifying only to the extent caused by your negligence. This also can give you a way to compare what a client may propose as your indemnity to what it ideally should be. It really should be this narrowly tailored. And of course, in California, you'd have that express disclaimer of the duty to defend. A couple other things about indemnity: mutual indemnity and incorporation by reference. Mutual indemnity is exactly what it sounds like, that each party, both you and your client, agree to indemnify each other. Typically, we're going to pretend that it's exactly mirror provisions. And sometimes it'll be two provisions identical. Sometimes it'll be a little bit different, but for purposes of the argument, the discussion, we'll say they're identical. Or it could be one provision just saying each party agrees, etc. With mutual indemnity, almost always it will be broader than the indemnity we showed on the prior screen. A lot of times it'll have the duty to defend. It will not be limited to the extent caused by damages or negligence, And the client will say, hey, consultant, there's no need for you to worry about this being broadly drafted, because we're going to agree to indemnify you to the same extent. So yeah, we accept and we understand it's broad, but we're going to give you that same benefit. The problem with that is this. Most often, you are going to be the one who is being required to indemnify your client, as opposed to the other way around. So I would rather have it be a one-sided indemnity where you agree to indemnify the client, but it's appropriate, as we talked about here, than to have a broad mutual indemnity, because the reality is you're probably not going to ever receive the benefit of that broad indemnity. It's typically going to be you being required to indemnify the client. The last thing is incorporation by reference. And this is, as I say here, almost always not in your best interest. It comes up all the time where you might have a perfectly acceptable indemnity, but then the next sentence will say, notwithstanding the foregoing, professional agrees that it will assume the same indemnity obligation that its client assumed in the prime agreement. Well, now we have a problem, because we can presume, based on the way it's phrased, that something is more broadly drafted in that prime document incorporated by reference. So recommend taking that out and making sure that the indemnity in your contract is nicely tailored, narrow, as we've discussed with the points on the prior slides. All right. So this is just kind of a cheat sheet. These are all the concepts that we've talked about as we've gone through indemnity. Might be worth, I don't know, maybe even printing out this section or this slide in particular and kind of keeping it handy as a reference guide. Project schedule issues. This is huge. We know time and money is the name of the game when it comes to having a successful project and a satisfied client. First and foremost, is the schedule reasonable? Is the client expecting something that is feasible? And can you comply with it? If you know from looking at the contract that the schedule is just, there's no way this can possibly happen, even in the best circumstances, the best economy, no COVID issues, no supply chain issues. You just know this can't happen. Then you need to speak up at the contract negotiations and manage the client's expectations. Time is of the essence is language that is in so many contracts. I would say I see it in, I don't know, probably 80% of the contracts that I read. And the problem with this kind of statement is that it essentially is a guarantee that you will comply with the client's schedule regardless of any intervening factors, regardless of any circumstances or delays that are beyond your reasonable control. So this should be deleted and should be replaced with language saying, you can certainly say you recognize that the schedule is important to the client. However, professional must be guided by sound professional practices and therefore will perform only as expeditiously as is consistent with the professional standard of care. You don't want that guarantee of the schedule in your contract, because if it's there and the project does go off schedule, you've got a guarantee that is problematic for you. Liquidated damages are inappropriate for you as a design professional. You see them in trade contractors agreements, totally fine for them. But for you, they should be deleted. They're not covered by professional liability insurance, and you don't want, again, this kind of ties into that guarantee of the schedule where each day the project runs behind schedule, you're going to pay the client some defined, $1,000 a day or something like that. That can add up quickly. So should not be found in a professional services agreement. If there are damages for delay addressed in your contract, it has to be limited and tied to your negligence. So almost always, if you see a damages for delay provision, it'll say, if there's any delay that arises from your services, you're responsible for any and all damages and liabilities. Well, that's elevating the standard of care. If you're going to be responsible for those types of damages, it should be limited to the extent the delay has been determined in a binding dispute resolution mechanism to have been caused by your negligent performance. Fast track is a concept that it's a project delivery method where multiple phases are happening at the same time. It inherently presents issues with coordination. There's an increased likelihood of necessity for redesign. If your client is telling you in your contract that they want this to be a fast track project, you'll want to include some qualifying language in there to protect yourself. And after the webinar, if anybody's interested in that, reach out to me and I can provide that. Force majeure is the last part, and I know we're going over this very quickly. I mean, we could really spend a whole session just on these 6 bullet points on this slide. But force majeure ties back into this concept. It's kind of the opposite of a time is of the essence provision, because force majeure is a provision that allows you to not be responsible for breach of contract or delays for circumstances that are beyond your reasonable control. And before the pandemic, if there was a force majeure provision, it was pretty much boilerplate. Nobody really spent much time on it. I know I didn't. I kind of, breezed over that section pretty quickly. But once COVID hit and we were seeing, all those ships in the just stuck waiting for things to be delivered, all of a sudden, this concept of damages and delays beyond the professional's reasonable control became very important. So we took a hard look at what we thought was an appropriate provision for a design professional to include. And we kind of beefed up what was kind of boilerplate to say that included in that list of causes beyond your reasonable control include but are not limited to impacts from widespread infectious disease outbreaks, including epidemics and pandemics, delays because of government shutdowns or delays, failure of the client. So we expanded that to have the list of things that fall under the umbrella of force majeure be broader and kind of reflect the current time. So that's another provision. If you're interested in seeing what our generally recommended language is after the webinar, you can send me an email and I can send that to you. But I still do now here in 2023, I still do recommend in the provision or the contracts that I review that design professionals do include a separate force majeure provision. Okay. So, I forgot that I included it. Here it is, even better. So you can see this kind of provision, we want it to both be broad and specific. And what I mean by that is we've got this laundry list of very specific things that we want to be included as reasons, factors that are beyond your reasonable control. But we also want it to be open-ended, which is why we say including but not limited to delays because of, and here are all the things. So I'm glad I included this. Here's our standard language. Client provisions, I have found, are often not as protective as this. So you may want to have this also as a resource for future contracts you look at. Okay. Next up is dispute resolution. And this is another area of the contract that really should be addressed. You don't want to just leave it silent. We recommend requiring the parties to mediate disputes prior to litigation. So mediation is a great mechanism to resolve disputes when the parties come to the table open-minded and really prepared to try to resolve a dispute. It is voluntary, it's confidential. It's a great way to try to preserve the client relationship because it is less confrontational, because at the end of the day, if the parties cannot reach a conclusion, they don't have to, then it would be, the dispute would go to the binding dispute resolution procedure, which is typically either arbitration or litigation. So by definition, it's less confrontational and allows the parties to hopefully preserve that relationship. Now, sometimes mediation is unsuccessful and the dispute does go to either arbitration or litigation. So the question is, well, which one of these do you want to pick and which one do you want to specify in your contract? We do recommend litigation over arbitration. Arbitration has some cons to it, and here they are kind of listed here on this bullet point. In arbitration, you don't have to have follow the rules of evidence. There may not be discovery unless you put that into the contract. But one of the big things with arbitration is that there's no appeal to an arbitrator's decision. At the end of the day with arbitration, there is going to be a decision. It's not like mediation where the parties can discuss it and try to figure out a viable solution. In arbitration, you're going to have either one or a panel of arbitrators who ultimately will decide and tell you how much each party is responsible for, who's responsible for what damages. But with arbitration, you really don't have any rights of appeal, except for maybe, fraud of the arbitrators, which of course is very rare. Contrast that to litigation, where you do have discovery, the rules of evidence are followed. You do have rights of appeal. So those are some of the reasons that we recommend litigation. Proponents of arbitration have long said that it's faster and cheaper than litigation. That may or may not be the case. Certainly, as a result of the pandemic, I think courts are still backlogged, but we have not seen sufficient evidence to suggest that arbitration is faster or cheaper. So at the end of the day, we still do recommend litigation to the extent the parties can't resolve their dispute in mediation. A couple of things here at the bottom. Beware of attorney fee shifting provisions. This is also sometimes called prevailing party provisions. And essentially what these provisions, has to be in your contract, say is that the loser pays the winner's attorney's fees. And here in the US, we have what's called the American rule, which means that each party essentially carries their own water. Everybody pays for their own fees. So if you have this provision in your contract saying loser pays winner's attorney's fees, that is something that you have taken on in your contract that is an obligation that you would ordinarily not have under applicable law. And as such, it will most likely fall under an exclusion in your professional liability policy for assuming liability under your contract, the contract liability exclusion. So from a business standpoint, sometimes people really want to include these because they think, well, if we're the prevailing party, we can get our fees back. But the converse of that is that it's something that's excluded, kind of like the duty to defend. So if this is triggered and you're required to pay prevailing parties fees, that would be an out-of-pocket cost. The other thing to be cognizant of is that you may not know how the prevailing party is defined. Sometimes even worse than that, your contract will define it. And I've seen crazy definitions in contracts of what the prevailing party is. Obviously, they're always weighted in favor of the client. It may say the prevailing party is defined as the party who prevails on 10% of its claimed damages. Wow, that's probably not good for you. I mean, it's not necessarily a high bar for a client to prevail on 10% of its claimed damages. That's just an example. But you do, from a risk management and professional liability perspective, we do recommend deleting these, even if they're mutual. Last point on this slide is waiving your rights to a jury trial. Anytime you see language in your contract asking you to waive any rights that you would ordinarily have under law, you want to pay close attention and think about how that could impact you down the line. With respect to the jury trial, you do have that right under applicable law. I tend to take that language out so you're not waiving that right. Some people say, well, I'd rather have a judge decide the dispute because there's no way a jury of my peers can possibly understand the complex issues in the AEC world. And I would counter that with saying that if you have a good attorney, and hopefully you would, that it has their bread and butter be these types of disputes, that attorney should be able to adequately educate a jury. Kind of along the same lines, there's no guarantee that a judge that would be assigned to your case would be an expert in these types of issues either. So I don't think that that waiver of your right to a jury trial benefits you at all. So I would delete that. All right, let's see where we are. Okay, use and ownership of documents. A couple of you did put this as a provision that you found difficult to negotiate with your client. And I can see why, because I have found over the years of reviewing contracts that this area of the contract has become very, very confusing and definitely more favorable to your client. As a threshold matter, we recommend that you try to maintain ownership of your documents and provide a limited license to your client to use them. You definitely want to make sure that you get paid before you turn over your documents, especially if you do decide to give ownership of your documents. Giving the ownership of the documents is not considered a deal breaker from a risk management and professional liability perspective, but like I said, you want to get paid first. You want to limit your client's use of your documents to the use, completion, and occupancy of the project for which they're intended. And ideally, you want to try to get an indemnity running in your favor if the client reuses or modifies or any future use of your work product. Copyright is another animal all in of itself. And I will tell you that years ago, I rarely ever saw that a client wanted copyright of your documents, but it is commonplace today. And copyright convey significantly broader rights to the client than just giving ownership. If you grant copyright of your documents, or sometimes it'll say that your documents are, quote, works made for hire, and they'll cite some federal statutes. That kind of language, by definition, means that the client is the author of those. And you essentially lose all rights to use them. And arguably, you could be sued for copyright infringement if you then use, say, your standard details that were included in those documents. So again, this is another area of the contract we could spend an entire session on. So I just want to hit the high points. But if you do decide to grant copyright to your client, you definitely want to include some additional protections. And this is a little bit long, but it's unfortunately necessary. So you want to make sure that the client, if they produce or create a derivative work based on your work product, that they remove your seals and logos, that they agree that any future use or reuse or modification without retaining you is their sole risk, and you want that indemnity in your favor. You also, and this is very, very important, you also want this last part here, this last two sentences, that essentially reserves your right to use your standard details no matter what kind of rights you grant to the client, because the last thing you want is for all of a sudden your standard details are unavailable to you for use. So in an ideal world, you're not going to grant copyright, but if you do, this is some suggested protective language. One other thing on this slide we didn't talk about is confidentiality requirements. And you see this all the time in contracts. Usually it's one-sided, saying that you're going to keep the client's documents and their information confidential. I don't have a problem with that as long as there are some exceptions to that. You don't want it to be ironclad where there are absolutely no exceptions. Ideally, if it's in the public domain, you shouldn't be required to keep things confidential. If it's reasonably required for you to defend yourself, or at a bare minimum, you want an exception that if disclosure is required pursuant to a legal order that you receive, that you're allowed to disclose information. Okay. We don't want to have this all be doom and gloom. So we do want to talk for a few minutes about some provisions that may provide you some protections in the event a claim is made against you. And the two big ones that we talk about here are limitation of liability and waiver of consequential damages. Both of these provisions, I always recommend in every contract I review, I give the language. This is our Beasley standard language for limitation of liability. And with these types of provisions, you want them to be broad. You want them to limit all liability, the total liability of you and your employee, the client, for any and all losses and claims or damages whatsoever that arise out of or relate to your services. So the question becomes, well, what number do we stick in there? What do we do? And we always recommend that the liability amount, and it's the last three lines here, shall not exceed the total compensation received by you or some amount certain that the parties negotiate. And the reason we say fee received is because that is probably less than your overall fee. So that's another way to kind of bring that number down. And then as to the amount that you negotiate, it is ultimately a matter of negotiations. Clients typically are loath to accept these types of provisions, but we do recommend you try to get them in. A lot of times client provisions will try to limit your liability, but the amount is to the insurance requirements. Well, if you're on a project and your fee is $5,000, but you're required to maintain a 1-1 insurance policy, that doesn't quite seem equitable. So if it's tied to your insurance at all, it really should be tied to the available proceeds at the amount, the available proceeds of your insurance at the time of resolution of a claim, because as we all know, professional liability insurance is a depleting limits policy. So just because you have $1 million insurance policy, at the time of this claim, there may not be $1 million left, because it is by definition a depleting limits. A couple other things with limitation of liability and with consequential damages waivers: be aware of exceptions to these provisions. And you do see this all the time. You may have an outstanding, just perfect provision, but then the next sentence will say, this provision in no way applies to professionals' indemnity obligations or professionals' negligence or breach of contract. Well, that pretty much makes this provision moot, because that's what you're going to be sued for negligence and breach of contract. So when you see those exceptions, be very aware, because a lot of times it makes these provisions such that they provide you very, very little substantive protection. Next is waiver of consequential damages provision, and you can see that this is a mutual waiver. We don't have a problem with you agreeing to waive consequential damages, but let's talk first about what consequential damages are. Consequential damages are damages that are not direct. So let's say you have a building and there's a leak and it destroys, let's say it's an apartment building and it destroys water damage to 4 different units. The direct damages are those damages necessary, or the resulting damages, to fix the building, to fix the leak. But the consequential damages are those that lost rent, that lost revenue, the indirect damages to that water damage. So these are particularly important provisions to have on projects that rely heavily on the stream of commerce or revenue. So shopping malls, casinos, restaurants, things where if there's a delay, that those damages, those indirect damages, those loss of profits could be huge. So for example, let's say it's a shopping mall and it was slated to be open for the holiday season this year to get all the holiday shoppers. But instead, the project was delayed and it didn't open until the springtime. The client would argue, you know what? I lost $8 million of profits that I would have otherwise had if this had been on time, if this project had been open for the holiday season. So this type of provision, this type of mutual waiver prevents that argument. So again, with these, just like limitation liability, be aware of exceptions to this waiver language rather. Okay. We have to talk a little bit about contractual insurance requirements. Number one, you want to make sure that you have the required limits. So obviously talk to your broker to ensure that you understand what limits are required and that you have those limits. You want to make sure that you're communicating with your broker on this. If you are retaining subconsultants, often you are going to be required to flow those same requirements through to your consultant. So you want to check with whether they have that required insurance limits and whether or not it's even available. Sometimes the limits may be way too high that your consultants can't even reasonably obtain those limits. So you want to make sure that that's appropriate. And then again, sometimes prime contracts can come into play here about what kind of limits are required and what you have to do and what your consultants have to do. Additional insureds, that's a concept. If you see that your client wants to be named an additional insured on your professional liability, red flag should be going off that this client does not fully understand how professional liability insurance works, in that you cannot have additional insureds on your professional liability insurance, unlike some other types of insurance. And the depleting limits concept also can come up. I see pretty regularly now where the contract will say that if your insurance policy limits erode at all, that you will replenish those. And that's a big red flag, because it conflicts with the inherent nature of a professional liability insurance policy that is depleting in nature. So if you see that, tread cautiously, because you do not want to be in a position where you're constantly having to replenish a policy that by nature is depleting. Okay, and then bonus topic. We actually do have a couple minutes, so it's always nice to talk a little bit about email protocol, and I will also throw in text protocol. A lot of these things are very basic, they're common sense. Think before you send it. Don't send things when you're angry. Obviously, do not use profanity in emails. Keep your feelings and opinions out. Be professional. Humor does not translate in email, so don't try to be funny. Reply all can get you into trouble, because you may not mean for everyone in that reply all chain to see everything. So be cautious when you see long email chains. I recommend, if you have a long email chain, start right from the bottom and scroll up and read everything, so you're fully informed of what's in that email. And the reason we say all of this is because emails are discoverable. In the event of a claim, and they have been for many, many years now, in the event of a claim, all those emails that are part of your IT and computer system, they will be discoverable, and you will have to produce them. And a lot of times, emails can be very damning to a professional, whether it be actual substantively, in the sense of, boy, oh boy, we really messed this one up. You obviously don't want that to be discoverable. Or even if it puts you in a bad light, in the sense that, they've got profanity in them, they're really unprofessional. You don't want a judge or jury to see that putting you in a bad light. So kind of the rule of thumb I always say is, if you don't want your priest or your mother to see an email, don't send it, because in the event of litigation or claim, it will be an exhibit. It will be discoverable. With respect to text, I would encourage you to not use text for anything substantive, because text messages are discoverable, just like email. If you have to use text, and I recognize that we live in an age where we all do, but it really should be limited to things like, meet me at the whatever, for scheduling purposes, not for substantive things. If it is substantive, then it really needs to be reduced to writing and put in the project file pursuant to your document retention policy, and just good documentation and good project files. So be very, very careful with text. Email is such a casual form of communication. We've been worried about it for a good reason. Texting is even more casual, and we're all guilty of it, sending that text immediately, and that could be problematic when you're talking about a project and substantive issues. So with 1 minute left, we are at the end. If anybody does have any questions, you can always send me an email. But Jonathan, do we have any questions?
Hi, Colleen. Fantastic presentation. So we did receive a few questions throughout the presentation. I just want to confirm just to
I
answer all
do.
those questions.
Yep.
Fantastic. So we'll just go through the questions. So first, a comment or statement from one of our audience members, Doug. Doug says, I frequently find that large companies will not sign up for indemnification and liability clauses that offer me any protection. He follows that up with, similarly with liability insurance coverage. Some demand $10 million. How would you handle this, or how can he handle this?
Yeah, it's very difficult. I mean, the large companies and some public entities are very, very difficult to deal with. Often they will send the contract and say, sign it or don't sign it or get out of the way so somebody else will sign it. The limitation of liability discussion is a difficult one, because clients want you to just be able to completely, basically guarantee your work. And if anything arises out of it, you're going to take ownership of it. And that is a fundamental discussion that ties back to the standard of care. I do think it's reasonable if you have a modest fee on a project that you should not be um, taking on all liability for a project. I mean, risk should flow to the party that's most able to control it. And certainly you're going to stand behind your work and comply with the standard of care, but the client does have some risk inherently in project as well. The 10 million, 10 million, these crazy high limits, you may need to get your broker involved with that and simply use them and have the broker get involved. Like sometimes you can't reasonably commercially obtain those limits. And that's a valid argument. If the client is willing to pay for the delta in the premium cost for you to get those, that's something that we do recommend. That's language that is in some industry standard documents, but it is difficult. And the limitation of liability, at the end of the day, that is a business decision. It's not a deal breaker from a professional liability perspective, but obviously we like it.
Fantastic. Thank you. Doug, thanks for the question. This next question from our audience member, if your contract is based on components, for instance, FPGA vendor pieces, which are known to have bugs, would you even have a negligence or errors and omissions clauses?
I don't know what FPGA vendor pieces are, um, but I think what they're asking maybe is whether we would include a standard of care provision. I'm not exactly sure what the question is, um, but if the question is, should we have a standard of care? The answer is yes, you should.
If that isn't what the question is to our audience member, feel free to send it, clarify and send another comment or question in the comment section. But we appreciate it. This next question, Doug asks, do you have an example of the California clause regarding the duty to defend?
Yeah. So California, like I mentioned, is um, it's tough. So this goes back to cases that were in the 2008, 2009 type frame, the Crawford and CH2M Hill cases, where the California court said, hey, you can't just delete the express duty to defend. So it might say, professional agrees to defend, indemnify, and hold harmless, blah, blah, blah. In most other states, you can just simply delete the word defend, and that duty to defend no longer exists. But in California, the courts, and this was something that was on the books, it's ancient, but the court said, yeah, you know what? There's an implied duty to defend. Even if the word defend is not in that indemnity obligation, professional, you have an implied duty to defend. Now, the courts also said, if you include an express disclaimer saying, nothing in the foregoing shall require the professional to defend any claim arising out of the services or project, that's acceptable. That is enough to take out the implied duty to defend. So yes, we do have a specific sentence. I don't have it in front of me right now, but essentially you want, there's a million ways you can draft that, but essentially it has to be this concept of disclaiming expressly that you do not take on the duty to defend. It can even, I think, be as simple as professional agrees to indemnify, parentheses, but not defend. You just want to disclaim it in your contract.
Doug, hope that answered your question, and thanks for sending in your question. This next question, I guess, trying to understand it. Keith asks, and I think this is in regards to the use and ownership of documents information you provided. Documents, does it equal software source code or engineering drawings? Do those count as documents? I think might be the question.
It might, depending on how that is defined in your contract. I have seen it ridiculously broad, saying that your documents, your work product include things that, aren't yours, computer programs, things like that you had no, like Microsoft Word, you don't own that, but you sometimes see that definition overly broad. So it depends how it is in your contract. Certainly, any kind of documents that you're giving a license to use, that you're giving ownership, you want to make sure you get paid first. That's like huge, because once you turn them over, you can't get them back. So if you haven't been paid
Mm,
and you turn them over, like, you're kind of out of luck. You don't have much to stand on at that point.
great advice. Thank you. Um, this next question, Brendan asks. Sorry. Brendan asks, with Outlook, is it possible to automatically delay sending emails you write, for instance, by 5 minutes? And if I'm understanding correctly, I think Brendan might be asking, is there a setting that you can set for that, or
I think that there is. I don't ever do that, Brendan. And I'm like a little bit old school, so I'm not the most IT savvy. Jonathan probably knows the answer to this better than I do, but I do think you can schedule when emails go out. I think that's a functionality of Outlook, but that's something that I'm sure you could easily even Google that question and it would
mm,
give you like steps.
there, at least to my knowledge, there should be most of those programs should have a scheduling option,
Yeah,
whether you can actually set it to automatically send every email or delay sending for every email. Not sure about that, but might be an option someday.
yeah.
Thanks for the question, Brendan. Um, and we do have we've received some questions regarding the slides, whether they can get access to them, folks. So just to let you know, this webinar will be available on demand at any time afterwards for viewing. So every slide that was in the presentation, you can view through that post live stream. We will follow up with Colleen later on to see if we can get her permission to share those with our audience. So stay tuned for that.
That's
Um,
fine. And Jonathan, if I can just interrupt for 1 second here.
Absolutely.
Um, so at Beasley, we have a relatively new risk management offering that, unlike our other risk management offerings that are exclusive to our policyholders, we have something called Managing Risk Together videos. And these we send out, beyond just our family. So if you follow me on LinkedIn or Beasley's LinkedIn, you will see them. So they are short videos. So you'll see my smiling face, between 3 and 6 minutes long. And they do address these types of issues. So 4 have been released. So if you send me, a LinkedIn connection request, you will see them. I don't post a ton of things, so you'll see them all right there. But they can be valuable because they're not crazy long, but they do address some of the topics even that we've talked about today.
Folks, I just found it online and I will post a link to it right now. You can access the rest of the links or videos through that web page that I've just posted onto the stream. And for any additional questions, you can also reach out to Colleen by through our contact information as well. But I think that's it for our questions. Colleen, thank you so much. Really appreciate all of this. I know it was for our audience. It was a lot of information. We could go on and on about this.
We could.
Again, for any additional questions, definitely be sure to reach out. But thank you so much. We really appreciate the insight you provided into the importance of a well-drafted professional services agreement.
Well, thank you for having me, and I wish you all good contracting. I know it's a lot of work, but it definitely behooves you to take the time to try to get them in place.
For sure. And thank you to our audience for tuning in and for your great questions. First off, did you know that IEEE has an exclusive insurance program for members that can protect you against negligent acts, errors, and omissions? A mistake can jeopardize your future as a consultant, so get the protection you need with professional liability insurance. Whether you're part of a firm or own your own business, we have a plan and coverage that meets your needs. And as an IEEE member, you'll have access to choice coverage from established approved insurers, including the Beasley Group. To learn more about the IEEE member professional liability insurance program, visit IEEEinsurance.com. We've provided the link on the screen as well as the contact information to reach a representative. Before we close things off, I would like to mention that today is the last day to book your cabins and secure a spot to join us for the IEEE USA 50th anniversary celebration cruise powered by the IEEE Member Group Insurance Program at the lowest guaranteed rates. To book your cabin, you can go to cruiseieeeusa.org. And pardon me, let me just pull that in. And yeah, we can't wait for you to join us in October for a week of fun, networking, and relaxation. Please like and subscribe to our channels and check back daily on our social media for future live stream updates. Have a great day, everyone.
Bye.